This lecture discusses policies and factors that outweigh the reasons for implementing an agreement. It considers first whether or not certain people, such as minors, incompetent people, or intoxicated individuals, have the capacity to contract. What that means is that they have the legal ability to enter into a contractual relationship. The discussion of the capacity of minors to contract may surprise some of you. Many may find it hard to believe that a 16, 17, or even some 18-year-olds can avoid contracts. Others may be surprised to learn that minors have any contractual capacity at all. Generally, courts presume that parties to a contract have contractual capacity, but there are situations in which capacity is lacking or could be questionable. In some situations, a party may have capacity, but also have the right to avoid liability under it. Minors, for example, usually are not bound by contracts. Therefore, certain contracts are voidable. A voidable contract may be either validated or avoided or canceled at the option of the party that lacks the capacity. Other contracts may be void. A void contract lacks an essential element for the formation of a legal contract, and thus either party may ignore it. In most states, the age of majority for contractual purposes is 18. Some states provide for the termination of minority on marriage. A minor can enter into any contract that an adult can enter into, except a contract prohibited by law for minors. Subject to exceptions, contracts entered into by a minor are voidable at the option of a minor. Disaffirmance: for where a minor to avoid a contract, he or she need only manifest an intent not to be bound. A minor may disaffirm an entire contract. An adult who enters into a contract with a minor cannot avoid contractual duties unless the minor opts to avoid the contract. A contract can ordinarily be disaffirmed at any time during minority or for a reasonable time after coming of age. The duty of restitution is where generally a minor need only return the goods or the other consideration, if they are still within his or her control regardless of their condition. In a few states, minors have a duty to restore the other party to the position he or she was in before the contract was made. Exceptions to a minor's right to disaffirm involve misrepresentation of age or contract for necessaries. Now, in most states, a minor can disaffirm even if he or she has misrepresented his or her age. In many states, however, this bars disaffirmance. Others prohibit a minor who engaged in business as an adult from disaffirming related contracts. Some refuse to allow minors who misrepresented their age to disaffirm contracts unless they return the consideration. A minor who enters into a contract for necessaries such as food, clothing, medical care may disaffirm the contract, but must still pay the reasonable value of the goods. Without such a rule, minors might be able to buy necessary goods. Ratification is an act or an expression in words by which a minor, on or before reaching majority, indicates intent to become bound by the contract. In general, any act or conduct showing an intent to affirm the contract will be deemed ratification. An executed contract is more likely to be deemed ratified. But what about parents' liability? Generally, parents are not liable for the minor children's contracts. If a parent is a co-party, then they're going to be liable. Generally, minors are also liable for their own torts unless a parent fails to use proper parental control. Emancipation is the release of a minor by his or her parents, who repudiate parental obligations and completely relinquish the right to the minor's control, care, custody, and earnings. Emancipation may be express or implied, absolute or conditional, total or partial. Several states allow minors to petition for their own emancipation. In some states, if a court agrees that a minor may be treated as an adult for business purposes, the minor loses his or her right to disaffirm. Intoxication is a condition in which a person's capacity to think or act is inhibited by alcohol or some other drug. Many courts look at objective indications to determine whether a contract is voidable because of intoxication rather than inquire into a party's mental state. If a person is intoxicated enough to lack mental capacity, a contract entered into at the time may be voidable at his or her option, with, in most states, full restitution. Being so intoxicated means being so impaired as to not comprehend the consequences of contracting. There is a court case out there where two individuals at a bar that were drinking entered into a contract. They spelled all the terms out on a piece of paper, or actually a napkin, and signed it. Well, the next day the individual decided he didn't want to be bound, so he said that he was too intoxicated to enter into a contract. The courts did rule that he was not too intoxicated because the fact that he went through all the specifics of the contract and was able to write down all of these specifics gave the court reason to believe that he was not impaired to the degree that he did not have the ability to enter into that contract. Mentally incompetent people. When a contract is void is when a court has adjudged a person to be incompetent and appointed a guardian. Any contract made by the incompetent is void. If a person has not been adjudged incompetent, any contract entered into by the person is voidable if the individual does not know he or she is entering into a contract or lacks the capacity to comprehend its subject matter, nature, and consequences. Voidable contracts may be disaffirmed or ratified after the incompetent becomes competent or by an appointed guardian. Now, if an incompetent understands the nature and effect of entering into a certain contract, the contract is valid despite a lack of capacity for other activities. Similarly, an incompetent may have a lucid interval during which he or she will be considered to have full capacity. So, let's look at an example in closing. Should retailers enter into contracts with minors and intoxicated individuals? Sales personnel, particularly those who are paid on a commission basis, are often eager to make contracts. Sometimes these sales individuals must deal with minors and intoxicated individuals, both of whom have limited contractual capacity. Therefore, if you are a retailer, you should make sure your employees are acquainted with the law governing minors and intoxicated individuals. If your business involves selling consumer durables such as furniture or automobiles, your sales personnel must be careful in forming contracts with minors and should heed the adage, when in doubt, check. Or I like to say, when in doubt, pause. Remember that a contract signed by a minor, unless it's for necessaries, normally is voidable, and the minor may exercise the option to disaffirm the contract. Employees should demand proof of legal age when they have any doubt about whether a customer is a minor. In addition, because the law governing minors' rights varies substantially between the states, you really need to check with your attorney concerning the laws governing disaffirmance in the state you live. You and those who hire to sell your product should know what the consequences will be if a minor has misrepresented his or her age when forming a sales contract. Also, you need to find out whether and in what circumstances a minor, on disaffirming a contract, can be required to pay for damage to goods sold under the contract.